For decades, Idaho had crimes written in its codes that would usually go unpunished, and they usually had to do with what went on in your bedroom. For example, fornication between two unmarried people was illegal in Idaho, had been since 1921. Adultery could get you 3 years in prison or a fine of $1,000. That law was passed in 1905. Sodomy, the infamous crime against nature, that was illegal since before Idaho was even a state. You may notice I'm using past tense to describe these laws. That's because they were considered antiquated, some of them unconstitutional and very rarely enforced. And last year, Idaho's legislature rewrote the code to get rid of them, which is kind of how the ACLU is looking at the No Public Funds for Abortion Act when it comes to what college professors can talk about in class. And we talked about this a little bit yesterday and how they filed a lawsuit to stop it from being enforced. The law has been in place since 2021, and up to now, no professors have been prosecuted for promoting or advocating for abortion. But the ACLU's view, if no one would accuse a teacher for violating the law the way it is written, then why is it necessary to have it at all? Here's Andrew Bartline.
A 2021 law is set to be tested, the No Public Funds for Abortion Act. Supporters say the law ties the same string to all public dollars.
No taxpayer money would be used to promote, provide, or counsel in favor of abortion procedures.
And no one is exempt, including colleges and faculty.
So yes, folks have been reaching out to us on this particular issue.
Leo Morales is the ACLU of Idaho executive director.
We have challenged it in court. At this point, professors fear prosecution, fear being put in jail simply for doing their job.
The lawsuit named 6 professors individually. They say ethics classes can only look at one side of the abortion debate, and literature classes can no longer read essays explaining the ethical dilemma of being an abortion provider.
So we have a major issue with this particular law of targeting only one side of the debate as opposed to both sides.
So like content neutrality?
Absolutely. This particular law is problematic in that it censors and it punishes professors for actually looking at both sides of the debate.
But ask who wrote this law.
Yep.
Blaine Canzati.
This is overblown.
And he says that's not true at all.
Academic discussion taking place in the classroom on topics related to abortion and various perspectives on abortion is allowed under the law.
At least it has been so far.
Has anyone been prosecuted for this that is faculty at a university yet?
Mm-hmm. We hope not, but the threat is real.
What leads you to believe that somebody could be prosecuted for this if it hasn't happened yet?
Before filing this lawsuit, the ACLU sent letters to prosecutors whether they were going to enforce this law or not. We didn't hear a response.
A couple of the professors are saying exactly what you said, content neutrality. I want to teach something in a neutral academic way. But then the question you ask the prosecutors is present ideas that favor or promote abortion. That language doesn't seem the same to me between the letter you asked the prosecutors and then the examples that you have in your complaint.
Well, we were hoping that prosecutors would affirm, right, that the way the law is written right now is unconstitutional and affirmatively say, look, it doesn't make sense for us to actually prosecute based on this law that's flawed.
And you didn't get that?
We did not get that.
Who responded to you?
No one responded to us.
The ACLU isn't just looking for an exemption, they're asking for an injunction, permanently.
This law, as written, should have never been on the books, and we hope that the court agrees with us.
Well, this law as written could have been amended last legislative session. Here's a look at that proposed language. Specifically, it says, quote, to the term promote, I should say, shall not be interpreted as preventing, and we should have a graphic we could throw up for you guys now, and if we don't have that, my apologies. Brian, here it is. To promote shall not be interpreted as preventing any classroom discussion on the subject of abortion at a school, college, or university. So that language of promote, that's something we touched on yesterday. But
right.
Brian, a big reason we came back to this today was because that letter to prosecutors not affirming that they won't prosecute this, the language is inconsistent. It says, will you promise us that you're not going to prosecute faculty for promoting abortion in class? But then all the complaints in their lawsuit are about neutral content in classroom discussion about ethics. Those two are not the exact same thing. We didn't really get an exact answer on it, but we do know exactly what they want out of the lawsuit.
I would imagine, too, prosecutors may be a little reluctant to kind of show their hand on whether or not they're going to prosecute somebody based on a law that's on Idaho's books, especially if they're not getting that direction from the top attorney in the state.
And it might be a case-by-case basis as well. You'd have to see the specific case to know.
All right. Thank you very much, Andrew.